Force One podcast, bringing you reading the Constitution, Part 3. We are going to pick up where we left off. Yesterday we finished Article 1, Section 9, and today we are going to pick up with Article 2, Section 1. This is by far one of the most poignant articles in the Constitution because it directly is applicable to the No King's March yesterday. This is the way that we have decided to be represented internationally and to have a form of leadership during their term in office. But this does not give them the ultimate powers of a king that a certain somebody is trying to run off with here. So, Article 2, Section 1 of the Constitution of the United States states, "The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and, together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector." So right there, the first two things is this article says how a president and a vice president get into the office, and then it says whether or not the state legislature has anything to do with it. And in the state legislatures individually determine how they choose their representation as electors. So that means that it was always the intention of the federal government for federal government elected officials who were representing states to be chosen at the state level. "The electors shall meet in their respective states and vote by ballot for two persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, direct to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president, if such number be a majority of the whole number of electors appointed. And if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum of this purpose shall consist of a member or members from 2/3 of the states, and a majority of all states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president." Now, this was changed by the 12th Amendment. And in order for us to understand how a president and a vice president are currently being elected, we have to know that what this says is changed by another amendment, and that is the 12th Amendment. So before we step away from it, there's a lot of people talking about what our senators and our Congress people and our two-party system, whether or not it was or wasn't meant to exist when the Constitution was written. And from this reading right here, just today, this is our 3rd episode, we can see for sure that the Founding Fathers did not intend for a two-party system. They intended for, and everybody who wants to run puts their name in, and the first 2 people with the highest level of votes becomes the president and the vice president. And so what they have here, they have written then from the 5 highest on the list, the said House shall in like manner choose the president. So they're, in fact, imperatively stating that they know that there's going to be a lot of people running for president, and you're going to have to worry about the first 5 on that list if the majority isn't reached by a single candidate. What this means is that they designed a no party system. People don't like to hear that. People get upset when you talk about the party system wasn't even an intention. But when they were building this document, they had come from a country with a legislature that had a party system. It had the Whigs and the Tories. It was a 2-party system, and it was failing them. They weren't interested in repeating that failure. And now we're in a position where our party system is failing us again. And in part, we're blaming the electors. But as you can see from here, the electors aren't actually the problem. The way that the president is being elected is part of the problem. We will have to get to Amendment 12, which is coming eventually. I mean, I'm still only at Article 2. We could, I guess, skip ahead if we needed to. Maybe we'll think about that tomorrow. Right now, we're just going to continue reading. So, the Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. So the Congress says we don't choose your electors, but we choose when your electors come to us. No person except a natural-born citizen or citizen of the United States at the time of the adoption of the Constitution shall be eligible to the office of president. So at the time of the adoption of this Constitution, is no longer valid, because anybody who was alive at the time of the adoption of this Constitution, if they are still alive, they're vampires, and we probably don't want them for president. No person except a natural-born citizen shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have been attained to the age of 35 years. Attained means reached or come to the age. So, and been 14 years a resident within the United States. Hi, welcome for coming. So this last one, and 14 years of residence within the United States. So I have heard a lot about the legal clauses with Mar-a-Lago and him only being allowed to be in residence 21 days because it's actually a business and it's got a tourism limit for the number of days that you can stay there. So my theory here is that on the moment that he's there the 22nd day, that's no longer a residency, that's overstaying a legal residency permit. And that also means that he's receiving mail not as residents, but at a place of business. And we know for sure that people who receive mail at places of business and who do not actually have residencies, we call them homeless in America. So we don't have a president who's been 14 years a resident within the United States. We have a president who's been homeless in the United States, but not a resident. And this matters because at the time this was writing, people with homes were settlers and people who were not homed were Indians. And so you were using the resident status literally as whether or not they had a house and a location. And if it was inside U.S. territory or inside Indian territory or inside Spanish territory, this really mattered when they wrote that. And so the words "and been 14 years a resident within the United States" literally mean that. So a homeless guy who's migrating from New York to Florida in order to evade charges is illegally using a business address for his residency. This sounds like the migration he's persecuting, but maybe that's just me. If you think I'm wrong, let me know in the comments. In case of the removal of the president from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until the disability be removed or a president shall be elected. And so, we have an order in the United States government of who's in charge if we lose a human in the rank and file of the American structure. So they like it's even to the point where on days where all of them meet in the houses to hear like the president, there's one guy who's not there. Just in case something happened to all of them, there'd still be somebody in charge of the government. And what this says is that we can remove presidents. And when we remove them, we remove everybody. Hi, Milo. We remove everybody. And when we remove everybody, it's their cabinet members, it's the vice president, and then we pick somebody to be in charge who wasn't of that issue. You're welcome. And then we move on because we're like planned and prepared for this. So we're going to keep going here. The president shall at stated times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected. And he shall not receive within that period any other emolument from the United States or any of them. So what is this? He gets compensation and it can't be changed while he's in office. And then also he can't get emoluments. Well, what the hell is an emolument? Emolument means like extra money for a service rendered. So like it's bribery. You can't be bribed. That's what that means. So, all right. Before he enter on the execution of his office, he shall take the following oath or affirmation. Now, here's the deal. We watched them do it. They have to do it twice, once in public and once on the Bible with the Chief Justice. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and I will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. His job is a constitutionally granted position, and he's got a constitution he has to abide by. In corporate speak, this is a CEO with terms of a contract for how he's allowed to be the CEO. And the fact that he wants to act in a way that is detrimental to the contract means that in the CEO world, we would be able to, as a board of directors or shareholders, be able to have him removed for failure to do the job. All right, so that concludes Article 1, Section 1, and we're going to move on to Article 2, Section 1. We're going to move on to Article 2, Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States except in cases of impeachment. And so right there in the first paragraph of Article 2, Section 2, we can confirm that the president does have the right to be in charge of the Army, the Navy, and the militia of the several states. The militia of the several states we now term the National Guard. And as that National Guardsman from Portland pointed out, the National Guard has a United States and a state mission, and both of those missions are valid. The National Guard is supposed to defend its own state from foreign invasion, and then if another state needs help, it can be deployed by the president. Now, there is a lot of argument over what constitutes an appropriate deployment of the troops, and we will see here that there are actually restrictions. So we're going to continue. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. And he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper, in the president alone, in the courts of law, or in the heads of department. But the Congress may, by law, vest the appointment of such inferior offices as they think proper, in the president alone. It says there that the Congress can let the president pick inferior offices and they don't have to be involved in it. That's like part of why a president has a cabinet and why there's Senate confirmations, but they're not doing that for every member of the administration. The president shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. So these are limited terms. He shall from time to time, Section 3, Article 2, Section 3. He shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on ordinary occasions, convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he thinks proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. What does that mean? That seems like they gave him a lot of power to do stuff. He may, in extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. That means if the House and the Senate don't agree and they're in flux, there's a constitutional clause that allows him to make them stop, to make them take a break, and that he can keep them in adjournment until such time as he has changed his mind. The implication of that is that we would be in both an extraordinary occasion and in a disagreement between both the House and the Senate. So it's not just like it can't just happen. There's stuff that has to be in place first. That is probably one of the closest rules we have that are kingly in some way. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Okay, so they're not using the term felony here, but a felony is a high crime. It's a crime higher than a misdemeanor. It's the highest crime, in fact. That's why when you are a felon, you have rights stripped away. Like some states take your gun rights. Most of them take your voting rights. Florida apparently is really great about taking certain people's rights and then arbitrarily changing their laws so that other people can have rights that people didn't have before. They are fun like that. We're going to continue. We are now moving into Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So right there, it is not the judiciary that establishes more courts. It is Congress. So when people are like, it's not the job of Congress to change how many people are on the Supreme Court, literally Article 1 says it is the job of Congress to work on the inferior courts and as established, is vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. So as again, Congress makes the courts, not the Supreme Court. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. So that means you can't be a felon and still be a judge. You obviously weren't being well behaved. And it also means that if you have a certain level of compensation, it's not going to go down. They're not going to renegotiate your contract while you're in office. And I think, what time is it? Yeah, okay, so that's about my 20 minutes. I'd like to thank all of you for joining me today for reading the Constitution. We're going to pick up again tomorrow on Article 3, Section 2. This is, 20 minutes for freedom at 4. and I've been reading the Constitution. I appreciate you stopping by with me, and I wish you a great day.